Well, ladies and gentlemen, my name's Professor Kathy Liddell, and I am the director of the Law Faculty's Centre for Law, Medicine and Life Sciences here at Cambridge. And on behalf of our centre and the Cambridge Festival, formerly known as the Cambridge Science Festival, it's my pleasure to welcome you to the 2024 Heyden de Lancey Lecture, which will be delivered by Professor Sir Jonathan Montgomery, a very distinguished lawyer from University College London. Jonathan's going to be discussing I think this is a correct framing, but we're going to find out more, the power of unelected judges to decide when a doctor has breached the law. And before we get to tonight's main event, I'm just going to take a few minutes of your time to introduce the proceedings. First, I'd like to mention a word or two on the origins of the lecture. We are very grateful that this lecture series is supported by the university's the Heyden de Lancey Fund for Medical Law Research and Teaching. The fund was bestowed by a foundation in Jersey that was set up in 1970 in the memory of the rather extraordinary Baron the Heyden de Lancey. The Baron was a doctor, a lawyer, and a financier, amongst all sorts of other achievements. And following in his footsteps, the lecture series has a long history of inviting distinguished interdisciplinary speakers. And tonight is no exception. Professor Sir Jonathan Montgomery's research and teaching interests focus on the intersection of law, healthcare, and bioethics. He's published extensively on a broad range of topics, and this little list is just a tiny, tiny set of examples, but his publications include informed consent, innovative clinical care, pediatrics, data sharing, abortion, so quite a wide spectrum, as you can see. And alongside this, he also wrote a landmark textbook, which redefined the study of medical law as healthcare law, drawing attention to the large number of organizations that are involved in regulating healthcare. Professor Montgomery has a long-running connection with Cambridge. He was a student here for the law tripos and the LLM, so he has something in common with the students I see here tonight. And he was a member of Gonville and Caius College. He was appointed to his first chair at the University of Southampton in 2001. And less than 20 years later, in 2019, he was awarded a knighthood for services to bioethics and healthcare law. And through his knighthood, Sir Jonathan was given the right to a coat of arms, which are part of the posters for tonight's lecture. He designed it to represent the entwinement of law and medicine for the common good. So you'll see the scroll of Eunomia, who is the Greek goddess of law and good order, sits within the coils of the serpent making up the rod of Asclepius, which you may know is the symbol of medicine. And then in a tribute to his education in Sir Jonathan's badge, which we don't have a picture of, this image is held in the paws of a lion to represent Cambridge and his secondary school, which both have lions in their crest. So I think that's really nice imagery, and I think very fitting for tonight's talk. Professor Montgomery has also been a member of numerous high-level committees. Not least, he chaired the Nuffield Council on Bioethics for 5 years, the Human Genetics Commission for 3 years, and the Health Research Authority for 7. He's also headed up a number of task forces on brain banking, organ donation, and pandemics. So in short, Sir Jonathan has made a major contribution to the governance of all sorts of medical aspects in our life. And as such, I think you'll agree he's an outstanding choice to give tonight's lecture. His title is Medicine and the Rule of Law. Snappily, he has told us that doctors should be ruled by the rule of law, not ruled by lawyers. And I, for one, am really looking forward to finding out more about this. Just before I hand over, a couple of logistics. The lecture is being simultaneously recorded and web streamed for those who cannot join us in person. We will have live Q&A at the end of the lecture. bringing us to a conclusion around 6:15 p.m. And people online are able to submit questions using the icon at the bottom of their screens, and they'll be collated at the end. And with that, I'd now like you to join me in welcoming Professor Sir Jonathan Montgomery in the customary way.
So thank you very much. Technically, that is the badge that you've got. What you have in the bottom right-hand corner is the whole thing, into which the scroll of eunomia and the rhodoschisis sit. I can't claim to have the same professional experiences as Baron de Lancey, but I was privileged to study at Keyes in a college full of lawyers and medics. So I feel that the intertwining of law and medicine had been a big part of my life for a very long time. And what I want to speak to you about this evening is a plea to myself and my colleagues to think more seriously about what we understand the rule of law to require, and be a bit less aggressive about what we think we know about medicine. And I'm going to talk, therefore, about the rule of law as an issue about discipline. So it's really important that medicine, like every other walk of life, is subject to the rule of law, and we should worry if any part of life, be it medicine or government, is above the law. But also the rule of law carries with it some responsibilities to think through how it operates appropriately. So I'm going to use a number of cases in which the law has grappled with challenges around medicine, and think about how we should understand the rule of law in relation to, first of all, its rule-based approach. So are we thinking properly about the role of rules of law within the rule of law as a discipline? I'm also going to reflect on what I think is inadequate reflection on how we should think through the separation of powers issues when issues of contested ethical concern come before the courts. So this is broadly the unelected judges telling doctors what to do challenge, although it wasn't a phrase I'd necessarily adopt myself. But we need to think quite carefully about when we think that it's legitimate for judges to grapple with these difficult questions, and how and when judges should defer to Parliament, as well as a challenge about whether or not we think judges should ever defer to doctors. And then I'm going to reflect a little bit on what I think is a degree of indiscipline, particularly amongst academics, when they think the law is onto a good thing and they don't think quite hard enough about the legal method that we were all supposed to learn as part of our discipline. And I'm going to do that in the context of informed consent. And in none of these areas am I particularly bothered by the outcome of the cases that we've got to. I think, generally speaking, the outcomes of the cases we're going to talk about make quite a lot of sense. But I am bothered about the routes by which we've got there. And I guess if I'm making a criticism, well, I am making a criticism of myself and others, it's that we've been a bit lazy and we've not paid sufficient attention to the discipline of law that we should bring. And I think if we paid more attention to that, we would be able to explain more clearly what it is that the law brings to the table when we're grappling with these difficult questions. So if I can just start with the bugbear of medical law, the reason why many people write about their concerns that doctors have been placed above the law. I just need to summarize, we'll come back to this later on, the sort of go-to test that I say to the students, if you can't remember anything else about medical and healthcare law, if you remember the Boland test and work on that, you'll be able to bluff your way through most things. I should perhaps confess at this point that when I was taught contract by Professor Lancey at Keyes, he told us at the beginning of the course that if you understood offer, acceptance, consideration, you were probably all right. So I only did offer, acceptance and consideration. It was one of the courses I got a first in. So it was obviously good advice, but it's not one I pass on to the students. But we would say that in many areas where the courts grapple with medical practice, they fall back on this fundamental idea that they are not particularly expert in judging it. And in order to make fair assessments of whether doctors have done the right thing, the starting point at least, and some would say the end point too often, is that we need to understand what the profession of medicine thinks is responsible practice. So in the clinical negligence context, we talk about whether or not doctors have acted in accordance with a practice accepted as proper by a responsible body of people from the appropriate specialty. I'm trying to exclude the sexism from the quotation from a case from the 1950s. And this becomes problematic if what it means is that provided doctors support each other, it's a closed shop and the law can't intrude. And if that were the end of the story, we would be very worried about whether or not medicine was truly subject to the rule of law. But that's not actually my primary concern tonight. My primary concern is the way in which the law gets sucked into things that are highly politicized or highly ethically charged, and loses a bit of sight of what it can offer as a tool for helping us resolve these highly contested debates. So I don't want to get into the content of the issues around the Tavistock Clinic and the decisions about that the NHS England has just made about whether or not puberty suppressing hormones can be offered by the NHS and now apparently only within a research context. But I want to worry about whether or not what we have done is allowed the courts to become the politics by another name, as opposed to bringing the discipline of law to bear on medicine. So there's lots of litigation around the Tavistock Clinic. We've got a context in which judicial decisions are being made when there's an awful lot going on outside the court. There's a lot going on in the media. People with concerns about what was going on at the Gender Identity Clinic were already using various other complaints processes. I had to recuse myself from the complaint that came into the Health Research Authority about the conduct of research study at the Tavistock Clinic, because it was led by a professor at UCL, and I therefore had to get one of the other board members to lead on that. We've seen employment law issues about the protections for whistleblowers. We've seen the regulatory authorities in the NHS, the Care Quality Commission, identifying poor practice, and we have a review which is apparently about to report from Hilary Cass, trying to get to the bottom of what has gone wrong and what needs to happen going forward. So the question that's in my mind on this is, what can we bring as lawyers to the resolution of those really tricky things? We're clearly not the only players. There are people with the stake about quality control for health services, the Care Quality Commission, the National Health Service in identifying when it's appropriate to spend public money, protections of people speaking out about things going wrong. But it came before the court as a campaign around trying to challenge, amongst other things, the consent capacity judgments that were made in the clinic. And this is an issue that I cut my teeth on as a young lawyer when I first started teaching, because it was a big issue around the campaign by Mrs. Gillick to prevent her children getting access to family planning and advice. And that generated the test of Gillick competence. And the High Court judge in the Bell and Tavistock case took the view that it was highly unlikely that the children who were moving through the gender identity clinic could give consent to the puberty suppressing hormones, and expressed the view that it was highly unlikely that 13s or under would be competent, doubtful if 14 or 15-year-olds could understand and weigh the long-term risks, but acknowledged that once they got to 16, a presumption of competence that the law made kicked in. With a certain amount of reluctance, it sounded that they were stuck with that. Now, when it went to the Court of Appeal, the Court of Appeal pointed out that there was no basis in the evidence put before the court for reaching that conclusion. There was some general evidence about child development, and the judge had plucked out of that evidence some presumptions that were age-based. Secondly, the Court of Appeal pointed out that there hadn't been a proper testing of that evidence because of the nature of this action, which was a judicial review action. The claims made by the experts were not put to proof in cross-examination. And so the judge had built this conclusion on a foundation that if we applied the appropriate disciplines of law, we should have resisted. And the Court of Appeal expressed the view that while that might have been very well intentioned, it also undermined the Gillett case itself, a decision in the House of Lords, which had held that you shouldn't use age-based cut-offs. You should understand whether or not the particular young person in question had sufficient understanding of the question to be able to understand it and give their consent. And in Bell and Tavistock, this was completely hypothetical. It would have been possible for Kira Bell to have brought a case based on the fact that her apparent consent was invalid, and that would have tested the evidence on her capacity. But it was a judicial review case testing the policy, so that didn't arise. And yet the judge felt sucked in to needing to answer a question which they needn't have answered on the basis of evidence that hadn't been tested in the way that you would expect to do when it really mattered. And the Court of Appeal found all sorts of other flaws in the reasoning as well to unpick that. So the issue here is about our ability to apply proper disciplines of the legal process to avoid ourselves falling into pitfalls of allowing personal views, whether those are ethical or views on the competence of children, to look as though they have a gravity they don't deserve in terms of a judge-made question. And that is where I might accept the claim that I'm arguing about whether or not judges are telling doctors what to do. But the problem we have is even more fundamental, I think, than the risk of being sucked into politics. We also find in some of these cases about difficult medical decisions that we find ourselves being moved away from what we usually recognise as the law. So in cases where we're dealing with withdrawal of treatment, so we're thinking of cases like the Charlie Gard case, I'll say a bit about later on, where medicine has reached the conclusion that it's now futile or ineffective or harmful to carry on with a particular treatment. And there hasn't, as there is in most cases, been an agreement between the family and the doctors about what should happen. The vast majority of cases are resolved by discussion. When those cases come before the court's job is to decide what it believes is in the best interests of the patient. And Sir Ian Kennedy has raised concerns about whether this is really law at all. So this is a discussion he's made some time ago, but it calls into question whether what we're doing is lawyerly. If what we're doing is merely expressing an opinion, it matters a lot who the judges are and their competence to do that, because their legitimacy needs to come from their wisdom. Whereas usually we think legitimacy in law comes from the fact that judges are applying rather than making the law, and we'd expect decisions to be driven by some clear principled basis. And Ian raised this question about the best interest test, and it has a number of layers of criticism that we should worry about. There's no general principle, he suggests, is just rhetoric. But it might be even worse than that. It might not be just rhetoric. It might be that we have principles, but those principles are secret, which is a rule of law failure. We can't have effective rule of law if the law is hidden, because no one knows what's expected of them and no one can organise their lives around it. He goes on to suggest that judges reason backwards. I think that's not terribly contentious about judicial decisions. No, but the point he's making here is that they only really tell us what the outcome is and they don't explain why. And in order for us to have legitimate governance through law, it needs to explain the conclusions that have been reached. So we need to understand the processes of evaluation, analysis, and the underlying factors. And unless we do that, the law is not providing a process of accountability, either for the clinicians or for lawyers. And his argument then is that what we've effectively done then is abdicate the rule of law and replaced it by rule of lawyers, although he wouldn't have used that phrase. And he says those lawyers are not held to account because they don't explain why they decide things. You can't really challenge it. And what you end up is unfettered discretion. Now, that's exactly the criticism we make of the Boland test in relation to medics, that it creates unfettered discretion. So if this is true about the court's role in these difficult contested treatment cases, that calls into question how well we are applying our rule of law expectations. And if you don't like the outcome of cases, you're going to find that builds a basis of distrust and suspicion of the role of law in the area. So the campaign group, calling itself Christian Concern, has talked about this as being not the rule of law, but the absolute power of a human being who is given the power to rule over the life and death of another person. Now, were we able to articulate those cases in terms of grounded principles, we would have the answer to that sort of challenge, and we'd say, no, this is not an individual dealing with it. This is someone through whom the law speaks, applying what Parliament and society has identified as the principles and embodying that degree of oversight. Unless we think that this is just an issue of campaign groups, Lord Sumption, former Supreme Court judge, in his Reith lectures, talked about the Charlie Gard case and described it as being a case in which the law ultimately made it a matter of the organ of the state, a family division judge in the High Court, and that the decision-making by the court was the, so to speak, the nationalisation of family life. Now, I think if those claims are true, then we shouldn't really be championing the role of the courts as being superior to the decision-making in medicine. So we need to think about what it is that makes it appropriate for the law to be involved in these areas. And the sorts of things I think we then need to think about is not the outcome of cases or the best interest principle, so much as what the process of legalization offers to our decision-making processes. So this is David Glass, who was looked after in a hospital in Portsmouth, and whose parents took the United Kingdom to the European Court of Human Rights to establish that their rights of due process required cases of this sort to be taken to court. And the Supreme Court has grappled with how we define which those cases are and when they need to come to court. But the essence of this is that the rule of law's function in this is to pull secret decisions out into the light of day and enable them to be challenged. And that requires us to have due process. So once you get to court, you need to be confident that the legal issues are tested and that the parties are properly represented. And that enables us to move from a position in which parents and families are at a disadvantage in their discussion with the doctors into an area where the role of law is to create a more even playing field and enable people to test what is claimed. If necessary, more investigations can be ordered so that if the evidence is incomplete and doesn't enable the judges to answer the questions about what's appropriate in terms of care, they can manage that process and request that information to be brought forward. And what the judges is doing then is assessing an evidential basis and reaching the decision. Now, that's built on the fact that if we're going to have power held under the law and not arbitrary power, then we don't want medicine to operate like that. We need the courts there as a background, but nor do we want judges to operate like that. So we then need to have a system of appeal, and we need to enable ourselves to challenge judicial decision makings. Although we find that easier, in theory at least, although I'll come back to this, when those decisions are mistakes of law, where appeal judges feel able to criticise what their colleagues have done. They're much more reticent to interfere with decisions about facts. And the reason for that is because the trial judge will have seen much more of the parties and heard much more of the evidence than an appeal court can never hope to do. So we usually are reluctant to see appeal courts interfering with decisions of facts. But if Ian Kennedy's critique is right, best interest decisions are just decisions of fact. and that neutralizes our ability to hold that to account. And then finally, the courts have the ability to continue their oversight, so that if in areas of disputes it turns out that the factual context has changed, they can bring matters back to court. And that happens very often in these contested cases. And one of the challenges that the judges are finding at the moment is how they can distinguish between a situation where the facts have changed, the situation has developed, and they need another look, and the decision where either the family or the doctors or their advisors won't give up and keep bringing things back. The rule of law ought to enable us to get some closure on these things, but it's quite hard to do in these very contested areas. So what can we see doing in these areas? Well, I think we see some examples of testing of evidence that give us some assurance that the law is adding value. So this is Charlie Gard and his parents. And amongst many things that happened in the Charlie Gard case, which went through a whole series of decisions and went all the way up to the European Court of Human Rights, there was a question about the credibility of the evidence that the family was adducing. So they had found a professor from New York who was happy to offer them prospects of treatment, which in cross-examination and testing, the judge found he admitted had a prospect of benefit of effectively zero. In the cross-examination and testing, the same expert accepted in the course of his evidence that the opinion he was putting forward was based on a theoretical construction. It was a process that had never been used on humans and only used in animals in different models, and accepted that therefore there was no clinical evidence that he could adduce to support that. And about 6 weeks later, he wrote to the parents saying that he expected the therapy would be beneficial, that in the best case condition scenario, Charlie's condition would stabilize and improve. And he was therefore offering something to the parents that he was not able to defend in the forensic process. Now that's quite an extreme example of the value that law brings to this, that it enables everybody, including the parents, to have some assurance that the basis on which they're taking their decisions has been tested. And I think that enables us to deal with some of the challenges which I've described elsewhere as a tragedy of these cases, using the sort of model of a Greek tragedy, that everybody is trying to do the right thing, but sometimes trying to do the right thing takes you to very difficult places. So clearly the parents love Charlie and are trying to do the best for him. The clinicians in the hospital, are endeavouring to form a judgment on what they think is appropriate. The scientist in New York is hoping to innovate to solve some of these problems. These are all good things to do, but the role of the law is to try and test them and see the point at which those emotional drivers have got us beyond the rational foundation, given that we need to make some form of choice. So I think the value the law is adding there is a value based on due process improving the quality of decisions. And it also enables us to identify cases where things go wrong and that we should worry about the breakdown of the rule of law. So the family on the right-hand side is the family of Alfie Evans, who died in Liverpool. And in the litigation around Alfie's case, it turned out that a doctor had flown in from Germany, had been in London seeing a patient called Isaac Harstrop, who's also the subject of a case, been up to Liverpool to see Alfie, had gone into the hospital, according to the court account, covertly pretending to be a member of the family. He had written a statement which he gave to the court about the prospects of Alfie's condition improving, in which he claimed to have seen the notes, which the court found he hadn't actually done, and noted that that was at risk of being found in contempt of court. And they found that that led to him offering an opinion of the family about what was possible that was actually dangerous. And around the same place, someone who said he was a law student, not I'm sure of this institution, was giving the parents advice about options they had and rights that they had, which the judge was very clear were completely misguided and emotive and rhetorical. And those things subverted the sorts of value that we might get from the law approaching these areas. And they have nothing to do with who is right or wrong. They have to do with whether or not our processes can lead us to more confidence in the reliability of the judgments. So that leads to a whole series of issues that we would need to spend a lot more time on, I think, if we are trying to reflect on the bringing of the values of the rule of law to these difficult areas of medical practice than is traditionally done by academics, particularly, where we get very interested in the ethical issues, interested in the power issues, and we've lost sight of what it is that we can bring as lawyers to this. So we should really worry if in this forensic process, people don't get a fair chance to make their case, test their case. In the Charlie Gard case, the lawyers who acted on behalf of Charlie and his family, or on behalf of his family, the lawyer acted on behalf of Charlie, was the official solicitor, were doing it pro bono. So we hadn't provided proper access to legal support to do that. And that is a big flaw in the rule of law. It's a more interesting one, I think, which we need to spend a little more time on in the future, which is whether or not the legal power that's brought to bear by NHS trusts is somehow stronger than that by claimants. And this was said a lot around clinical negligence cases in the past, that the hospitals had a load of specialists and many of the patients went into a local high street solicitor because that was their only way of getting access to justice. And there was a mismatch of power. I don't think that's true in the sorts of cases that I've been illustrating around withdrawal of treatment. And that's because there are well-resourced and articulated campaigns around those. So just to pick one example, series of cases around blood transfusions and Jehovah's Witnesses. And there's a Jehovah's Witness lawyer who is qualified in lots of different jurisdictions who flies in to argue the cases and pulls together human rights arguments from lots of different jurisdictions. So it's not the case that there's a big inequality of arms, but there is the case that our understanding of how the law is dealing with these things and the extent to which we are honouring rule of law principles needs us to understand rather better the way in which the work of lawyers operates. And there are some well-known, prominent people who make their careers in particular areas, whether they're defending hospitals or picking up particular ethical issues. And if those things operate well through the testing process that I've said we'd like to see, that gives us a much better, robust rule of law. But if they're coming playing games and saying this worked in Canada and we'll try it over here, it clogs up the system and takes, as we've seen in a number of recent cases, things all the way up to the European Court of Human Rights, when everybody knew there was no chance of those cases winning. But they're driven by the desire to use the law as a campaign in this politics. And one of the things you'll see if you look at the big cases on ethics, and I'll talk a little bit about some of the end-of-life care ones in a moment, is that we now see a large number of cases where people want to intervene in the issues to put before the courts the range of issues that they see are at stake, as well as the individual cases. And at present, the courts don't seem to be taking a lot of notice of them. They summarize what they've heard, but it's hard to see that they're having much impact. Understanding that is important because the people who are able to make those sort of interventions are not evenly resourced. Some campaign groups have a lot of access to support for that and others don't. And if we think the discipline, the rule of law requires us to have a degree of equality about that, as we would think about lobbying in Parliament, we need to think also about lobbying of courts. And of course, that's well understood in other jurisdictions, but relatively undeveloped in this area for ours. And then there are questions about whether or not justice is being seen to be done, even if Surrey and Kennedy is wrong, and there is a good reasoning process. Up until quite recently, many of these cases were heard behind closed doors. They're still often heard under conditions of confidentiality. And that raises questions about how we can be confident that what we hope is happening under these court decisions is what is happening. And we've seen a lot of activity in recent years about increasing transparency, regular blogs, tweets from court hearings. And we're now seeing an interplay between the rule of law through the courts and what is sometimes glibly cited as the court public opinion. And I could show you pictures of pickets outside Great Ormond Street, headlines on these cases. It's a bit of a two-edged sword. If justice has been done in secret, we can't be confident about it. If people are intimidated by the way in which it's used, we're not getting the rule of law either. And that's a challenge for us in capturing this. And then I think there's a question about whether or not what we see in these decisions is biased in the way that Ian Kennedy was worried. So if you look at a case like the litigation over Archie Battersby, which went through 11 court rulings in the 18 weeks that went through. So there's no lack of rule of law in activity in this. But there's some real questions that are raised by those who are unhappy with the result. So Archie's mother felt that the court refused to watch evidence that she felt she had of Archie's being able to breathe independently. You can watch it. It's on the Daily Mail site, I think, but the court wouldn't have a look at it. Their view was this was not new evidence. They'd been over this previously. This is one of those examples about keeping going rather than accepting the result. Christian Concern, again, I mentioned earlier, talked about there being a cultural shift amongst the judiciary, which has got used to ordering the removal of life support from disabled children. And has blinded judges and society to the obvious idea that something may be wrong with the original principle. Now, these are things that are sometimes discussed under the heading of epistemic injustice. The way our knowledge is created, what we count as knowledge, may be distorted. So if we deny people's chance to have a right in court, that would be a rule of law problem. Now, I don't feel that this is a problem in these cases. And the reason I don't is because there was an awful lot of airtime of these things in court. If you just had one hearing and the parties came and said we were not able to adduce the evidence we thought was relevant, we wouldn't have honoured our desire that the court process provides reassurance of good decision-making through that discipline of due process. So I spent quite a lot of time on that because it seems to me that in these cases of individual disputes, it's those sorts of questions about are we offering due process, which are a more important part of answering the question about whether medicine is appropriately subject to the rule of law, than arguing about what the meaning of the best interest case is, because the only meaning of the best interest case is really in the operation of it. Let me turn to another rule of law worry, which is about who we think should be the appropriate decision maker in areas which are there's really tricky ethical questions. And this is the orthodox view set out by Lord Brown Wilkinson in the Bland case. Bland was the boy crushed in the Hillsborough Stadium disaster. And this is what we usually say about it, that these sorts of questions around the interaction between medicine and law raise issues which are properly sorted out by Parliament, not judges. The job of the law is to apply the principles which society adopts, not to impose personal judicial standards. And the process by which in this society we sort out those principles is usually parliamentary. Now, there are lots and lots of examples of judges disregarding this and finding lots of ways of doing it, and I've written about those elsewhere. I want to talk about a particular string of cases which seem to me to show that the courts have worried about this and we haven't yet done the work of thinking it through. And they're all cases, almost all cases, around the issues around assisted dying or the right to die, euthanasia, medical assistance in dying, all sorts of questions. I just want to tell you a quick story about the unfolding of this to raise some questions about where I think if we take seriously the contribution to the rule of law, we need to go. So back in the early part of the millennium, I guess we're saying those days, Diane Pretty took the case that the law prevented her having control over her own dying because her partner would be prosecuted if he assisted her to die. And in what was then the House of Lords before our Supreme Court came in, the Supreme Court, the House of Lords took the view that this was not a human rights issue, it was a policy issue for Parliament. Parliament had passed legislation prohibiting assistance in dying in the 1960s, and it was not for the courts to interfere with that. Diane Pretty succeeded in the European Court of Human Rights in persuading the European Court of Human Rights that it was a human rights issue, that her rights under Article 8 to respect for her private and family life were engaged. But she didn't succeed in getting the European Court of Human Rights to say that the UK was out of line with its human rights obligations, because it argued that the protections that UK law thought it was giving to vulnerable people were legitimate and proportionate interference with that right. So we then get another set of cases in 2009, where Debbie Purdy succeeded in persuading the Supreme Court, the House of Lords, that the law we had was too vague. And it was too vague, so to such an extent that we couldn't say the rule of law requirements of certainty were met. I have issues with quite how they reached that conclusion in terms of what it was exactly was vague about it, or whether it was just they didn't like the outcome. But what's even more interesting is that at the same time in 2009, Parliament had decided to continue the law. It rejected an amendment that would have allowed people like Debbie Purdy to go to Switzerland and have assistance in dying. So when you step back, there's a clash in the separation of powers between what it was that the court should do and what it was that Parliament should do. And then in the Nicholson case, the Supreme Court got itself in a terrible muddle and decided that it was depending on how you cut the majorities, you can cut them in different ways, but broadly that we had a human rights problem, but they weren't going to say that explicitly by making a declaration that our law was incompatible with the European Convention on Human Rights. They were going to wait for Parliament to decide because it was institutionally inappropriate to exercise the right to express the view that we'd got it wrong. And they almost certainly did that because they knew Parliament was about to consider it and expected Parliament to move the law in a more liberal direction, and it didn't. So then we have a case, which is the one which is not about end-of-life care in this, which is a case where the Supreme Court decided that it was able to say that the Northern Ireland abortion law was at that stage, it's since been reformed to bring it in line with human rights, in breach of human rights. And in the course of it, and this is a summary of that case from the Court of Appeal in Conway, which is the next one, they decided that abortion was a matter on which courts are as well qualified to judge as the legislature, if not better qualified. But apparently assisted dying is not in that category. And that was the view taken by the Court of Appeal in Conway. And that then went to the Supreme Court, and the Supreme Court decided not to accept the case, which seems an odd thing to do, having been exploring the boundaries between the competence of the courts and the competence of Parliament. And this is what the Supreme Court said in its reasons. So Conway wanted to challenge the restrictions on his right to have help in dying at the time of his choosing. Nobody doubts, the Supreme Court told us, that this is of transcendent public importance. No one doubts the issue raises an arguable point of law. They also indicated that the considered opinions of conscientious judges could differ. Indeed, they differ amongst the members of the Supreme Court. So you get this far and you're thinking they're clearly going to take this case on and try and resolve this question about where the separation of powers should come. But then they say he's not sufficiently likely to get anything useful out of this to justify us hearing it, which presumably is a judgment he would make, and he wouldn't been there seeking it if he didn't think that. So what's going on here? It seems that in terms of the question of what law brings to these issues, we've got, how do I put this, quite a lot of judicial barking and not much bite when the crunch comes. Now, I think there's a perfectly good piece of work for public lawyers to do around this, because you could see this as in the tradition that you see in many countries in the world of a constitutional dialogue going on between courts and legislatures on how you get right the interplay of rights. But we haven't got that construction of what's going on here. We have what appear to be an inconsistent line of decisions. Now, the literature around this is mostly interested in, can assisted dying work effectively? Are the safeguards effective? It's not grappling with some of the questions about what are the rule of law frames in which we should be thinking about doing this constructively. So my plea is that we think a bit more about those things alongside those substantive issues. Now here it's going to get a bit trickier, I think, and if you may be sympathetic to this case, I may lose some sympathy now, because I've watched the earlier lecture in this series by James Badenoch about Montgomery. I want to raise some concerns about the discipline of law in the reconstitution of informed consent that happened in the Montgomery case. Now, I don't want to argue we've got the wrong test. I do want to argue that we haven't behaved very well as lawyers in the course of grappling with informed consent. So in the Montgomery case, Supreme Court case, deciding that patients should be told things that they regard as being significant, which is a very good thing. We see some discussion about the interplay, not between the separation of powers I've just been talking about, which is between the courts and Parliament, but the separation of power under the law between clinical freedom and judicial oversight. So the Bolam test is said to be a recognition of clinical expertise, and therefore not quite, I think it's wrong to say in practice a no-go area, but it's a light touch area when that applies. And then you've got something which is fair and squarely within the scope of the lawyers, which is exactly what are and how far do our rights extend and how they work. And it would be quite inappropriate to allow the medical profession to determine the scope of rights. But these things sometimes find themselves enmeshed in the same context. And you'll remember that when we're dealing with issues of clinical judgment, and the Montgomery case perpetuates this, if it is about expertise, we fall back on this peer review sort of test. So we don't do that for informed consent now. This is the test for informed consent, that doctors have to take reasonable care to ensure that patients are aware of material risks involved in what's being recommended for them, and also material risks in relation to any reasonable alternative or any reasonable variant treatment. And when we're asking what's material, we do that initially from the point of view of a reasonable person in the patient's position. And then we check whether or not there's anything about the particular patient that means that we should change our view on what is material, because for her or him, this might be a particularly material issue, which it wouldn't be for everybody. Now, the rationale for that is subdividing the expertise that's at stake. And the Supreme Court takes the view that there's a categorical distinction, a fundamental distinction between what the doctor does when she decides about what to investigate or how to treat, and what the doctor does when she's deciding what to do, talking with the patients. Now, Kathy and colleagues have been working very hard to try and take the Montgomery issue into that question about diagnosis and asking how it changes that. I think in Montgomery itself, they seem to think diagnosis is a highly medical skill and communication and risks is less, because they say, that former bit, possible investigatory treatment options, is professional skill and judgment. They get in a bit of a worry when they look at other aspects of the operation of consent, disclosure, to counselling, discussion, negotiation, shared decision making. And I want to pull out some of the complexity in order to be able to take us into a question of what we might expect judges to be doing in this area. Because they recognise that they've got an answer to some of these problems, but not answer to all of them. So they note that We know when people have to discuss things because of material risks. Montgomery's established that. We also know that we go to the Bolam test when we're doing things that are mainstream clinical decisions. And they say, we know that it's not easy to discuss things with patients. There's skill and judgment required to do that. But that skill and judgment is not the kind with which the Bolam test is concerned. They don't tell us what kind it is, but we don't really know what that test is. Now, I had no particular grouse with that. It seems to me that's common law working as it should. The Supreme Court has given us some guidance on what the test is. It has some ambiguities. We need to work those through, and we are working this through in the case law. So we learned from Montgomery itself that we're sticking with Bolam for identifying options. We now know from the Supreme Court in the McCulloch decision that when you're identifying alternatives, sorry, I've got the slide wrong on that, alternative treatments, what counts as reasonable variant treatment, we go for Bolam. We didn't think that was very likely, I'd say, but that's where we seem to have ended up. We stick with the Montgomery test of whether you're advising, and we need some more cases to work out what we do in terms of those. How do you attack a case where you did advise, but you did it badly? Now, I have no grouse with that. That seems to me what we should be expecting. I do have a grouse with the way in which, particularly the Academy and also some judges outside of their judicial role, have dealt with informed consent. And I cribbed the legal fairy stories from a very good article that Michael Jones wrote quite early on in this saga, so we were still in Sidaway. And it seems to me there are some perplexities from a rule of law perspective in the way that we've dealt with this. So we're very excited now because we think Montgomery has incorporated human rights into our medical decision-making. But after Sidaway, Ian Kennedy wrote that the message of Sidaway was clear: medical paternalism had its day. The same excitement came in Sidaway. We then spent quite a lot of time interpreting Sidaway, and some people tried to chip away at it. Some people tried to say that this was Bolam all the way through. But if we take a rule of law perspective, and we're now saying, isn't it really exciting? Montgomery is telling doctors they shouldn't be so paternalistic. They should be more into shared decision-making. Shouldn't we, from that position on a rule of law basis, have been telling people after Sidaway, the law is clear, what you have to do is good medical practice and stop faffing around with any other way of thinking about it, because that is what the ruling in Sidaway was said to be. We got very irritated by the fact that the courts still cite Bolam. We as academics don't like Bolam very much because we worry that it puts doctors above the law. I do an exercise every year with my students at UCL where we read all the reported cases that have cited Bolam and Sidaway and Belitho, one of the intervening cases, in Montgomery. And it turns out the judges still cite Bolam a lot, and they hardly ever interfere with medical decisions in those reported cases. But you wouldn't know that if you read the literature, which explains how much judges can now intervene. And I think when you look at the literature around informed consent, you see that we've been in rather a rush about seeing what we hope to see in those cases. So there was a lot of excitement when Lord Wolfe decided a case called Pearce and Bristol, and the textbooks started putting it in as a elaboration of Sidaway, which has moved us away to the judges being able to say, if doctors didn't think something should be explained, but it didn't stand up to analysis or wasn't logical, we could interfere. But if you were to read the Pearce case was a straightforward application of Bolam. The claimant lost on the basis that the disclosure was in accordance with a practice accepted as proper by a set of peers. So we've elevated in our literature a movement because we wanted to see it. We did it when the House of Lords in Chester talked about disclosure requirements, but no one spent much time in saying that that was a concession that was done by counsel in Chester. It wasn't a judicial decision that they had a breach of disclosure. It was accepted, and all the issues on causation. But again, the textbooks built a whole new doctrine of informed consent out of that, which now has been vindicated by Montgomery. But Montgomery does some odd things about that appeal process of interfering with the facts or accepting the trial judge. The one I like most, because I test it out with my students, is that Montgomery decided that a reasonable person in the patient's position would be more worried about whether or not a baby got stuck than they would about whether the baby suffered any harm. And they had to do that because the ruling of the first instance had found that if the mother in the Montgomery case had been told about the relatively small risk of harm, she would have gone ahead with the doctor's advice. And as that's a finding of fact, it had to be evaded. So in order to do that, they moved it to, well, a rather higher risk of the baby getting stuck was what she should have been told about. Now, I test that with my students, and they pretty universally come down thinking it's the risk of harm that a reasonable person would think was material. So I think there are some issues about that. But I think the really interesting question is whether or not we have applied our discipline of law in relation to the rules of precedent. Now, let me just flesh out, because I only have a few minutes left, the sorts of things that should worry us. And I don't want to push this too far because I think the outcome is a good place to get to. But I worry that we haven't done our job as lawyers in thinking it through. So the birth in the Montgomery case was in 1999. If, as about half the respondents in the work that Kathy and colleagues did about how people received the Montgomery decision, it was championed as a revolution in the law that's changed things, then we've retrofitted 15 years back a legal principle, which is usually thought to be a breach of our rule of law expectations. If, on the other hand, the decision in Montgomery was carrying forward the Bolam-type thinking about you have to align professional standards and legal standards, it's quite easy to say back in 1999, when Nadine Montgomery had her baby, the GMC was already advising people to do the things that the Montgomery case did. So you don't have a retrospective legislation problem there at all. Equally, we have quite strict rules on when the top court in the land, now the UK Supreme Court, is supposed to depart from its previous decisions. And it's supposed to do that in a limited range of circumstances, and it's supposed to explain when it does it. It didn't explain that it was doing that in Montgomery. And amongst the things we usually expect are major social transitions, which were articulated in Montgomery, and also the fact that arguments that were previously impossible to run now become significant, perhaps because of contextual legal change. So I've been back and I looked at the arguments that were run in Sidaway. And the arguments in Sidaway had all the things that are in Montgomery about how our changing expectations meant the doctors should be less paternalistic, that we had rights that we needed to deal with. And I think we have ducked our responsibilities as an academy to look at this carefully. And I think that is a risk of us having moved from a good claim that the law brings something really important to this to having undermined that claim by being a little bit lazy. I think we would still get to the same outcomes. So actually, I don't worry about where we've got to. I worry about whether we behave properly as lawyers. So how should we move forward? So I think what we're, the master's arrived. So I think what we're saying here, my argument is that we should have a little more humility as lawyers when we engage with doctrine and medicine, that we should attend a lot more to the virtues of due process. We need a little bit more wisdom about how we get the complementarity of the disciplines and not the antagonism. Hence, my heraldic badge having the integration of the two. And provided we can do that, I think we can, with honour, champion the rule of law and our role in it. And I think that because in my college, you move through the gate of humility, you acquire virtue and wisdom, the two sides of that gate, and you graduate with honour when you get your degrees. So thank you very much for listening.